Thank you everyone for attending today's webinar, What Every Practice Manager Should Know About Investigations, Audits, and Document Requests, brought to you by Guillermo Vietas of Friar Levitt. Please be aware that there will be a question and answer portion today at the end of the webinar. To avoid frequent interruptions during the webinar, please type your questions in the question box located on the right of your screen. They will be answered in the order received during the question and answer portion. Additionally, an electronic version of this presentation will be emailed to all participants following completion of today's webinar, and a recorded version will be available on the website for members only. Again, NJMGMA would like to thank you for attending, and I will now turn things over to Guillermo.
Thank you, Dawn. My name is Guillermo Vietas. I'm an attorney at Friar Levitt. My specialty is in healthcare law. I represent physicians, practices, nurses, all types of healthcare providers in matters involving Medicare audits, overpayment demands, also some white-collar criminal defense in cases involving fraud, waste, and abuse, as well as board matters and everything non-medical malpractice related that a physician or practice or advanced practice professional can possibly be involved with. As part of this, I've come to learn that there's quite a bit of regulation here in the industry. We're part of one of the most highly regulated industries in the entire nation, and that's why I put together this presentation, because I believe that every practice manager, every physician, every advanced practice nurse, or anyone involved in healthcare really should know about the different types of investigations, audits, and document requests. When is something actually a problem versus when something is routine? So without further ado, I'd like to start off with investigations in general. So as I noted, healthcare is one of the most highly regulated industries in the country. You have federal agencies, you have state agencies, you have licensing boards, and then on top of that you have civil statutes and criminal statutes, all of which regulate one aspect or more of the healthcare industry. A physician can make one mistake in his or her practice after years of pristine work, and it can completely derail the practice. The problems stem from it could be something very simple like suspension at a hospital that becomes reported on the National Practitioner Data Bank, that then has a cascading effect through credentialings within private insurers, with Medicare, with Medicaid, with board discipline. Everything is interconnected, and that's why certain investigations can really trigger this cascade, this domino effect, particularly when you're talking about federal and state investigations dealing with fraud, waste, and abuse, diversion or indiscriminate prescribing, which is the #1 cause celeb that exists right now in New Jersey and really in the entire nation. We're seeing a lot of additional investigations into anti-kickback violations, and these are just a few of the many other areas where we're seeing practices being investigated. HIPAA Phase 2 audits have been going on with increased frequency since the middle of last year. You can have OSHA safety concerns. You can have the EPA coming because they want to make sure that you have proper waste disposal if you have any hazardous waste at your practices. It really does run the gamut. Like I mentioned, it's highly regulated, so you have all types of agencies from the federal and the state level that are going to be investigating you. So moving on to the Board of Medical Examiners, those types of investigations are conducted by state investigators. State investigators are part of the state attorney general's office. It doesn't matter what state it's in. It's a local state authority. It's a state agent, and they basically come to your practice based on a complaint from a patient or some information, and they come to your practice because they need to gather something. It could be medical records, it could be whatever. They have subpoena power, and I'll explain how far subpoena power goes, but for right now, when they have subpoena power, essentially what they can do is they can approach you and they can demand that you produce certain records. That's the power of a subpoena. With a subpoena, though, it's very important to note that if you ever receive a subpoena, the subpoena is supposed to give you a reasonable amount of time to respond. Reasonable does not mean I show up with a subpoena to your practice and you have to hand over your records right away. Reasonable doesn't mean you have 1 day or 2 days or 3 days. Reasonable a lot of times means about a week, 2 weeks. It all depends on how many records they're asking you to produce. The best response you can possibly have is an investigator comes to your office, they serve you with a subpoena, they say, I need to look at all of these records, I need to inspect all of these records. The absolutely perfect answer here is we will provide you with all records that you are entitled to, but here is the card from my attorney. We will produce it through my attorney, through my attorney's office. That's the best thing for you to do at that time. If someone's trying to subpoena records from you, they don't have the right to interrogate you. They don't have the right to interrogate any office staff. They have no power to question anybody. They have no power to take the records from you that same day. So subpoena power has its limitations. What you do need to understand is that regardless of what state you're in, it could be the Commonwealth of Pennsylvania, it could be the state of Maine, wherever you are, if you fail to comply with the board, that is subject to discipline. New Jersey has a specific statute, and I believe every state has something that's similar to it, which makes it a duty to cooperate with the board investigations. Physicians and all other professionals that receive a license from a state have a duty to cooperate with that licensing board. That means they can subpoena, they can ask a doctor to come in to testify, they can come in and inspect the practice, they can require a narrative written response to a complaint. You have to respond to every board inquiry, especially in New Jersey, because if you don't, you can be fined and they can even take an action against your license. Now, when you're investigated by a state agency, like the New Jersey Department of Health, Pennsylvania Department of Health, they have more power than a mere board investigator. The Department of Health, for instance, can conduct unannounced inspections. If you have a practice that is part of the Vaccines for Children's program that's funded by Medicaid through, the federal government, you don't have you can't deny them access to the VFC vaccines, the VFC vaccine refrigerators where everything's being held. You can't deny them access to the premises. They have the ability, they have the power to inspect, they have that authority. They can do that unannounced, and they do it unannounced most of the time. They don't schedule it, and there's really nothing you can do about that. Again, an inspection of the premises, an inspection of the equipment, of the refrigerators by the New Jersey Department of Health, for instance, doesn't mean I get to interrogate everyone who's there. You have to understand that there's a scope, there's so much that they're allowed to do, and anything that they try to do beyond that scope, you can say no to, and you should say no to. If they have any questions for you, they should submit them to you in writing, or you should give answers in the presence of an attorney. Most of the times, will your answers be benign? Most of the times, are your physicians conducting the practice in a completely legal way? Absolutely. But just in case, you need to, make sure that you're, dotting your T's and crossing your I's, because you don't want to get tagged by the Department of Health, for instance, because once that happens, once they find something is wrong, for instance, a lot of pediatricians in New Jersey have been having issues in the last couple of years with the VFC program. So the Department of Health comes in and inspects. They find something is wrong. They now refer the violation to the Medicaid Fraud Division to recoup payment, and simultaneously to the board for whatever the failure may be. Let's say like a failure to document the lot numbers of the vaccines. Now you've got an inspection leading to an overpayment demand, an investigation by the Medicaid Fraud Division, which could always lead to findings or allegations of fraud that could be prosecuted criminally, and a licensure action. That's your worst case scenario. So whenever you have an agency coming through, if you're ever uncertain, if you ever don't know if you're necessarily doing everything correct, the right way, if you haven't consulted with an attorney to make sure that you're practicing in accordance with all the requirements in the New Jersey board and whatever regulations are particular to your practice, get a healthcare consultant, get some sort of attorney. Doesn't have to be my firm, can be any firm, anyone who does healthcare, and really try to make sure that everything is in line. Because if you're afraid that it's not, you really should contact an attorney when you have investigators in your office if it's something that doesn't feel routine to you. You got to trust your gut, because sometimes if something doesn't feel right, you're onto something. Federal agencies, that's when it starts getting a little more serious. They typically involve more serious allegations. A lot of times it's investigations into anti-kickback deals. Everyone's well aware of, in New Jersey, the biodiagnostic decision, where they found out that a biodiagnostic, a lab, was basically paying kickbacks to physicians to send them patients there to get their blood work done there. Even though the money issue wasn't a terrible, great amount, it's a kickback. And, you saw they're still now 2 years later still indicting people and convicting people of violations of the anti-kickback statute for a case that's now 2-3 years old for a referral that happened 6 years ago. Once the government suspects that there's some kind of anti-kickback going on or violation of the Stark Act against self-referrals, any fraud, waste, or abuse, they're going to target everyone who is involved in it, even if you're involved just a little bit or a lot. So whenever you have federal investigators coming by, it's important to get an attorney involved really fast, because you want to eliminate from the very beginning the possibility, that you can be a target. If you're a targeted investigation, you're really going to have to lawyer up. If you're just a cooperating witness, they're looking to you just to cooperate, then again, it's good to have an attorney who knows healthcare present, because when you're cooperating, and I've seen this happen to multiple practices, a cooperation can a lot of times lead to self-incrimination when you're handing over documents that you think is helping the government, but then the government's finding out, wait a minute, this is an improper referral agreement. So now the practice that was cooperating with the government is all of a sudden now the defendant in an accompanying case. What you need to understand is that most of the time there's more than one agency involved. Usually, let's say the DEA for healthcare matters and an FBI agent for the actual investigative aspect of it. There are parallel criminal and civil investigations. So what happens is they target a certain practice. They start sending out agents, questioning patients, maybe sending in an undercover agent. They're using every investigative technique. They're subpoenaing records. In the meantime, criminal and civil prosecutors at either the federal or state level are talking with one another, and they're both sharing information as to their investigation to determine whether the violations are criminal or civil. So whenever, again, you are approached by more than one investigator, you have to assume that something is happening behind the scenes, both at a criminal and civil level. Federal agencies usually involve higher fines and penalties than board or state investigators. For instance, the False Claims Act, the amount collected, has that's usually what they're after. So if they paid a practice $100,000 over a 10-year period for a particular procedure that was billed incorrectly, falsely, fraudulently, they're looking to collect that times a multiplier. They're allowed to ask up to a 3 times multiplier, and then they can ask for a per claim penalty. So each individual claim submitted of anywhere from $11,000 to $22,000. So all of a sudden, these penalties dwarf the amount at issue. So $100,000 can very easily become a $3 million demand or $3 million exposure. So again, we're dealing with the federal government and alleged federal violations. It really has to heighten your sense of scrutiny as to what they're asking you for, and again, getting an attorney involved right away. So investigations, some common misconceptions. Investigators do not have any kind of duty. There's no ethical requirement that they tell you the truth. This can be a police officer, this can be a state investigator, a DEA agent, an FBI agent. They are there to conduct an investigation. They are there to get a statement from you. And investigators, they don't only want a statement. What they want is they want you to admit to something. They want a confession. They want a statement against your interest, because a statement against your interest is hearsay, but it's an exception to hearsay that can be used against you in a court of law. So that's why when investigators show up, I've had some criminal defendants where they've given statements to investigators, to FBI agents, because they thought that the FBI was just investigating something routine, that they were one of many doctors, that they were fact gathering. And even when my former client asked if he should have an attorney present, the FBI agents basically said, well, it's your preference, it's whatever you want, but at no point in time did they tell him he was a target of the investigation. At no point in time they tell him that he was the only subject of the investigation, and that was completely fine. It's very important that you always understand that the person who's there, be it a bull in the china shop or the sweetest person in the world, they're there for a particular specific job, and that is to get information, be it through a subpoena, through whatever. The difference between a subpoena and a warrant is very, very important. A subpoena is, like I mentioned before, a document. It's a request that you have to comply with, but you can always try to quash a subpoena, meaning the practice's attorney goes to court and says that the subpoena is improper in some way and tries to get it invalidated so that you don't have to comply with the subpoena. Otherwise, a subpoena is just a document demand. You have to produce documents within a certain amount of time. Usually your attorney or consultant, whoever's working with the practice, can coordinate with the investigator, usually with the attorney who is in charge, and you get to produce it at your own pace a lot of times, even if it's a lot of records. A warrant, essentially you only have the right to remain silent. With a warrant, they can come in and they can ransack your office. They can take whatever they want. The only thing that I would say about a warrant, other than call your lawyer, your criminal lawyer right away, or a healthcare attorney right away, is when you have a warrant, you are going to be presented with a copy of it. Read it. The warrant will say exactly what they're looking for, where it's located within the office, and if they try to go somewhere that's not within that area, you have to let them know, you have to object to it, and you have to make a note of it, because anything that they find in an area that they weren't looking or that they were not allowed to go to is inadmissible. Also, a quick note about warrants and subpoenas. A lot of times investigators will show up with a subpoena acting like it's a warrant. And then when you make a very keen observation that, excuse me, Ms. Investigator, that's a subpoena, not a warrant, the investigator, she will say to you something like, okay, well then I'm just going to go and I'm going to get a warrant and I'll be back today, and I'll be getting all these records and I'll have you arrested for impeding this investigation. Anyone who says that to you, you can freely laugh in their face. It takes probably at least a week for someone to get a warrant. So that's not something that happens overnight, certainly never happens same day. And if it was so bad what they are alleging against you, they would have shown up with a warrant to begin with. So that's not something that you should ever fall for. Cooperation does not mean that they will give you future consideration. Like I mentioned before, sometimes you cooperate and they use what you cooperated with against you. So it's important to be mindful of what you're going to be turning over. So that's essentially what you need to know about investigation. As far as audits go, I'm sure everyone present here is well aware of audits, and they've had to deal with them in one way or another. Medical record audits obviously are supposed to target and evaluate procedural and diagnosis code selections. They're supposed to be meant to reveal your weaknesses in coding or documentation. It's funny because in the CMS manual, it actually says that they're supposed to be used as tools to help providers. It's supposed to be, there's an educational component to them, even though a lot of times they seem to be used only as a punitive means. But that is something to definitely keep in mind. Audits, they're going to reveal your weaknesses in coding and documentation. Sometimes you'll get an audit, it'll seem like it might be an overpayment demand, but it really is an actual test to see if there's any fraud going on. This is particularly the case with E&M codes that are the level 4 and 5s, because obviously MGMA data has shown over the years that the most typical codes for initial office visit and follow-up office visits are usually in the 2 to 3 range. So when you have a when you have a practice that builds a lot of 4s and 5s, they become an outlier. And once you become an outlier, you become the target of an audit. So that's something that you need to do internally. If you're building a lot of 4s and 5s, if you're doing a lot of things that might bring upon an audit, make sure to have a certified professional coder really look through your records to make sure that you're not doing anything that's going to put you at unneeded risk. So the first thing you're going to ask yourself when you receive an audit is, is this a routine audit? Almost every provider agreement that I'm aware of requires, on a routine basis to send maybe 3 or 4 charts, 3 or 4 records. It's a routine audit to make sure that everything's going right and everything's being billed correctly. That's the essence of an educational audit, a maintenance audit. That's not something to target. It's not a post-payment review. It's not a prepayment audit. So how do you know when an audit is routine? Well, first of all, how is the practice notified? Who sent the letter? Who addressed the letter to the practice? How many charts are being requested? Is this coming from someone at the Special Investigations Unit, or is this coming someone from the Audit Recovery Unit? Is this coming from the Medicaid Fraud Division? Who addressed the letter to you? How was the practice notified? Was this, did you get it certified mail? Was this faxed over? How many charts are being requested is the one that I usually like to focus in on. If you've got a large demand, 50 or more, I can guarantee you they're looking to take money back. 50 or more is a key number, especially when you're dealing with like a Medicaid fraud division. 50 is this magic number where they can have a statistically valid random sample. With a statistically valid random sample, you're allowed to extrapolate with a high accuracy. There's nothing, believe it or not, there's no minimum like error, percentage error for you to extrapolate. So they can request 50 records, find a 2% error rate, and then extrapolate that 2% error rate over 5 years. Unfortunately, you know, you're gonna be fighting a losing battle if you're gonna say that, you know, they should ignore that 2% overpayment demand. We've had some success with that in the past, but unfortunately, it hasn't been, you know, a unanimous success. But again, what you can attack is a statistically invalid sample. If they only ask for 10 charts and now they're asking for a tremendous amount of money back through an overpayment demand, you have to have a statistically valid random sample for you to be able to extrapolate. So whenever you see high numbers, you know, 50 or more, it's automatic. If you're talking about 20 or 30, okay, then maybe perk your ears up a little to that, maybe be a little more sensitive to that. If it's less than 20, I wouldn't worry about it because it's not a very substantial amount. So you're talking about, you know, statistically insignificant sample, so you can't really use that. They can't really use that against you. As far as, you know, is it pursuant to the provider agreement terms? You have to review your provider agreement. Take a look. You know, it should say in there how often you have to produce charts, how many charts. If you're ever concerned about, you know, if it's a routine audit versus an investigatory audit, take a look at the records yourself before sending them over. You can't change them, you can't do anything about it, but take a look at them themselves. If you see that every single record requested deals with modifier 25, you got your answer. You know why they're auditing you. You know, you might want to get a certified professional coder to take a look at those records and give you heads up if you've got any issues. If you see that it's just completely random, then maybe it is just a completely random audit. Some red flags. Well, I don't need to tell you, but if you get anything from a RAC auditor or a ZPIC, then you absolutely need to be prepared for some kind of overpayment demand. You don't want, this is where, you know, you may want to get healthcare counsel involved or a consultant who deals with these types of issues a lot, a certified professional coder, because you want to attack this, you want to attack it from all fronts, and you want to make sure that you do the best possible, you get the best possible results from this audit, because a lot of times bad, you know, RAC and ZPIC audits end up, the post-payment audits, they end up with prepayment audits. If you do poorly enough on one of those post-payment audits or post-payment demands, and they take enough money back, they'll say, we don't have any trust in your billing, for instance, modifier 25 or level 4 visits. So every modifier 25, every E&M new office visit is on prepayment review. And that can grind a practice to a halt. You also have to look for audit buzzwords, such as billing irregularities, outlier, which is my favorite one, fraud. You know, outlier, I hate that term because it's as if the government and private insurers have gotten together and decided that no one can be number one. No one can be better than average. You know, if you're not within the meat of that bell curve, then, you know, they think that you're a fraud. They think that you're doing something wrong. They think that you're gaming the system in some way. I've never heard of Medicare or private, you know, insurance companies contacting the people on the low end of the spectrum and saying, hey, I don't think you're billing enough, or we're not paying you enough, or are you sure you're not billing too low, you're not undercoding? Never say that, but they go after the top 10%, 15%, 20% and say, no, 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 you're an outlier, so you must be doing something wrong. Be very careful if you're ever talking to somebody from either the federal government or any insurance company, private or CMS, and they mentioned, an impossible day scenario, like you're billing too much based on your typical times. You're, billing more than 24 hours in a day. That's a new tactic that the government has tried over the last few years with varying degrees of success. I was able to defend a physician in New York twice on federal Medicare fraud charges. They were alleging an impossible day scenario. We were able to show that the typical times in the CPT code book are not required, and they're not even a good guesstimation. They're completely unreliable. So I've met with people from, some of the major insurers, I'm not going to say names, and in meetings with them, they've brought up, the doctor who was the target of an audit, and they started talking about, typical time and how many hours the doctor billed in a day. So this level of thinking, this misguided thinking, has seeped into now private insurers. So, if you have a busy practice, if you have a practice that bills a particular type of procedure a lot, like if you are an ENT and you have a balloon dilation procedure that you bill a lot, that's an area of target right now. That's something that you need to be aware of. It also brings me to my next point. Specific procedures, if you see that everything being requested is pursuant to one procedure that you do, it could be Mohs procedure, it could be a balloon sinuplasty, or a code like a initial office visit, consultation, or a modifier like modifier 25. That should also clue you in that this is not a routine audit. This is a specific audit. They're targeting something that they think I'm doing wrong. So at that point, you may want to, obviously, you're going to have to prepare the most complete records possible, but also you have to keep in mind that you have to maybe put in a little explanation for the reviewer. You don't have to, but I've seen that work to the benefit of practices in the past. Also, if you see a large number of documents requested, yes, 50 or more, obviously. Sometimes I've seen initial audits requesting 200 or 250 records. That's a considerable amount. So I would certainly advise you to, be very careful when you see a very large document request. I would always be careful when they want to come to your office to access your computer and to copy your records in office. I understand why they do that, and I'm sure all of you do too. It's, I've had many conversations, and they always harp on, program integrity. So essentially, they don't trust the physicians, they don't trust the staff, they don't trust that they're going to get the most accurate record. While I understand that, I always send a letter advising whoever is requesting to, come to the office, that the office is very busy, that the office cannot accommodate by giving a computer terminal to the investigator or investigators, that it would cause a lot of disruption, but that if we're given a list of patient records or data services, we will promptly comply with same and turn over complete records. Sometimes that works. Sometimes I say no. And at that point, you could get into a long fight, or you could just let them come and copy records. What I would not let them do, and I have objected to vigorously, is actually letting them sit down and go through your own records. Don't give them access to your computer. That could be a HIPAA violation. You don't know what they're looking for. I would suggest that you only look at, only let them copy records that you print out. Some do's and don'ts. There's a lot of do's and don'ts. I'm just trying to keep them to the biggest ones. First of all, do comply with the audit, okay? So you do have to turn the records over, and you have to make sure that you give them accurate records. I've had instances where doctors have completely ignored audits, and then that's a 100% denial rate, and then the overpayment demand is ridiculously high, and then we get retained after the fact, and we realize, oh boy, now we have to get involved, and we have to basically try to put the toothpaste back in the bottle. Comply with the audit. Don't be vindictive about it. There was a doctor, that we represented back in the day who decided it would be a good idea to produce all of the records requested in red paper. So he printed out all of his records on red paper. And the reason he did that is because you can't photocopy red paper. So he made it extra difficult on the auditors. The auditors did not have a very good sense of humor about that, and they denied every single one of his claims, which again starts you back not only at square one, it's at square negative one, because now you have to say, okay, please ignore what happened and let us start all over. Give us the benefit of the doubt. Copy all records. I can't stress this enough. Yes, they're going to ask you for specific dates of services, but a lot of times I've noticed that records get denied because, well, this part was missing, this history was missing, well, I don't have the supporting lab that was referenced in this follow-up visit. Give them all the records. You can't give them enough. Give them intakes, diagnostic testing, operative reports, anything that supports the date of service at issue. If you have a practice that uses a standard form for history, and things of that nature, and then the doctor just does a progress note on a separate sheet of paper or on the EMR, give them both, because they're going to need both to be able to give you credit for what you did. So make sure that the records are complete. Don't give statements. An audit is not a request or a directive for you to talk, or for any of your staff or doctors to talk. Do not give statements, and don't hand over control of your workstation. If there's an explanation that should accompany some of these documents that are requested, it's better if it's done through an attorney, so that it's not a statement against your interest if you say something that maybe isn't correct. Don't send illegible records, don't send sparse records, or fail to keep a copy of what was produced. That I can't stress enough. When you send out a copy, or when someone comes in and you have to print out a copy of your records for an investigator at your office, do not let them go away without you making an exact duplicate copy of what they took. Do not send out something that you're not going to keep an exact duplicate copy of. If possible, if it's a lot of records, bait stamp them, number them so that you know exactly, what happened. You know exactly what went out. You know exactly what records range they should have, 001 to 0145, whatever it may be. Keep a copy of what was sent, because that is crucial. Last, we'll talk about document requests. A lot of this stuff is similar to, obviously, audits. The document demands can really range from medical records to contracts with a practices management company or a hazardous waste disposal company. Essentially, we've talked about how practices and physicians are regulated, local, state, and federal level. Sometimes you'll get a document request that's informal. Usually those come from the board. They'll send you a letter saying, can you please send the board copies of all contracts between the practice and any management company of the practice. That is not atypical. That happens every once in a while, and there's no reason for you not to comply with that. Sometimes they're formal. They're a subpoena. When it's a subpoena, it's it's a formal request, and you really need to understand that a subpoena is a heightened sense of importance. You really can't say no to a subpoena unless you go into court and try to quash the subpoena, and that rarely happens. Once you have a subpoena, that is when I would get an attorney involved. If it's an informal request, figure out what's being requested and who's requesting it. If it's not an informal request, it's a subpoena, most of the time, some area of importance has been flagged. There's some red flag around the practice or one of the practices, areas of practice. That's when I would contact healthcare counsel. Warrants, again, are not requests. They're demands. If you get a warrant, that you have to immediately lawyer up and not let anyone give a statement until your attorneys can show up. Healthcare attorney, criminal attorney, or both, or one with both experience, with criminal healthcare defense experience. But you definitely do not want to proceed once there's a warrant in place alone. That is the biggest of all red flags. So, on-site versus production. We talked about this again with audits, but this is more for document requests. A lot of times, on-site document inspections, the reason we don't like them is because it's an unnecessary exposure to the practice. I've had too many instances where an investigator comes to the practice. I'll use, Department of Health investigators on a VFC vaccine investigation, okay? I'll use them as an example because this happens with more frequency than I'd like to see. The investigators from the Department of Health show up. They ask, okay, so where's the refrigerator? Where's this? Where's that? Show me the computer where you log into the NJ Mods or NJIS portal. Okay, can you please log on to that portal for me to show me that you've been tracking all of your vaccines? So you're going through that, you're showing them that, and then all of a sudden, they see, oh, you know what? I see you have some expired medication that wasn't disposed of properly, or that's in with unexpired vaccinations, and then they start asking questions about the practice, questions about who makes what decision. It goes from something related to this to then a more general inquiry. I don't like that. They're not there to do that. They're not there to interrogate. They're not there to ask questions. They're there to do an inspection. Some of the questions that they're going to ask you, yes, are relevant to their inspection, but you have to keep them in line and within their track. If an on-site inspection obviously can't be avoided, instruct your staff. Do not talk to them. Don't make eye contact with them. Have one person, the office manager, be the point person, or the physician be the point person, and that's it. You don't want other people talking and making statements that are contradictory to each other, or making statements that are misinterpreted by the investigator that are then put into an investigative report that are then used against the physician. I was before the board once where one of the practice's secretaries made a number of incriminating remarks about the doctor and the practice, that the doctor said, well, I talked to the staff member. She did talk to the investigator, but this is not what she said. Well, it's in the report. So because it's in the report, there's not much you can say. The reason I don't like anyone talking is because it's not like in some civil cases, you'll have an investigator question a potential witness. They'll talk. The investigator will prepare a report, will present that statement to the witness. The witness will read it, make any corrections or clarify any misconceptions, and then sign off on the statement. There's no such thing with a healthcare investigation by any agency. They ask a question, you answer it, and whatever they heard is going into their report. And whatever they heard is going into that report and being presented as it being your statements that are attributed to your practice. That's why I don't want anyone, I don't like anyone speaking to anyone from any agency unless you absolutely 100% are sure that nothing incriminating is going to come out of it, or if you have an attorney present, or if you're speaking, or if you speak with an attorney first. Again, keep track of everything done or said by the investigator at your office. There's been too many times where my client said, well, no, this investigator was here and said everything was fine. And then, they get a report saying that this practice is the worst practice in the world. You want to keep track of what they said to you, when they said it, who was present, who overheard it as well, who witnessed it. These are important things you may need down the line. Again, if documents are printed out, print a second version or make a copy of what you printed out so that you have a copy of what was sent out. Always know what was sent, always know what was copied. It's very, very important. Again, routine versus investigatory. This goes back to a lot of the same questions we had before about investigations, and audits. How many documents were requested? What type of documents are requested? Who's requesting it? Again, when you're getting a letter, make sure to read the title of the person who sent it to you. Is she from the Medicaid Fraud Division? Is she from a Special Investigations Unit? Or is she someone from the Compliance Department, which could be benign or could be bad? Does it relate to a hot topic area? If you are a primary care doctor and, it's about prescribing, that should be a red flag. Are they asking for contracts with a lab that you do a lot of work with? Is it particular to one type of drug? Is it an opioid drug? If it's a hot topic area, like prescribing or something of that nature, you absolutely have to start going on the defensive a little and get an attorney involved right away, because you don't want to send out anything that's incriminating. And sometimes we have had situations where a physician entered unwittingly into an agreement that they thought was fine because some drug rep or some rep of a lab or any other kind of company just said it was legal. Did they ask for an attorney? No. Did they ask for a legal opinion letter? Did they get their own attorney to investigate? No. The rep said it was legal and that other people do it, so we did it. That's the worst defense possible, and I've yet to see it work anywhere. Drug reps, any kind of rep, they are not lawyers. They are commission incentivized, and they're there to make sales. Lawyers are there to give you regulatory advice. Healthcare consultants are there to give you regulatory advice. If it's a hot topic area, this is just another just little tidbit. If it's a hot topic area, do not ever accept any advice from someone who is not an attorney. And if someone's an attorney, make sure to get something in writing. Again, routine versus investigatory. Is the request general or specific? If it's a general request, all right, I don't feel as bad about that. I don't have my, I don't think that raises any red flags. If it's very specific, if it wants to know how much of, substance you prescribe, that's absolutely a red flag, and you better lawyer up right away. If it talks about speaking engagements in general, that's fine. If it talks about speaking engagements with a particular pharmaceutical company or on behalf of a particular pharmaceutical company, okay, then you may want to get a lawyer involved there. Common mistakes. Again, I'm going to harp on this because I cannot tell you how many times this happens, not keeping a copy of what was sent out or copied. The worst thing that you can do to your lawyer is have records go out that you didn't keep a copy of, and then when your lawyer asks you for an additional copy so that he or she can include it in his or her submission to whomever, you give them a copy that's not the exact same as what was taken from your office or was sent from your office before. And that's happened multiple times to me. I hate it. Just destroys your credibility. It destroys the credibility of the attorney. It really, you think you're doing something good, but oh, well, you know what? They took these records, but there's this explanation that I forgot to put in there, or I made a couple of addendums, or no, you can't do that. Once you send out records, you can't go back and touch them. You can't go back and change them. I've had too many situations where that's happened, and all it does is make the board angry if it's a board matter, investigators not trust you, prosecutors then think that you really are conducting fraud. It's best if you always keep a copy so that you can just hand that over to your attorney. Also, giving statements to investigators without first speaking to an attorney, that can be a huge mistake. Producing incomplete or illegible records. A lot of times you get illegible records, they're handwritten, they get automatically denied. So don't send illegible records. Get them transcribed or offer to provide a key or something, but you can't just send chicken scratch and expect to be compliant. Treating all requests as routine. You can't just say, okay, I don't want to deal with this, another paper request, another request for records, medical records or whatever. Just give it to random staff member and they'll send it out. I've had physicians get in trouble for that because they get the same document request from 3 different parties to a lawsuit, and different versions go out because, okay, so this staff member thinks that letters from the court are not part of the medical records, so they didn't go out in the first production. Second production for the same requested records didn't include operative notes because they didn't think that was part of the record because, the doctor is, a pediatrician and he didn't do any of those operations. They're just part of, what was done somewhere else. So that's a second different version. Then a third version has even less records as a part of it. All it does is make the practice and doctor look bad, hurts the reputation, and it can potentially lead to some liability. That's why you always review what is being sent out because you want to make sure that you're producing something complete. Some final thoughts. Well, again, healthcare is highly regulated, full of pitfalls that even the best of intending healthcare providers unwittingly fall into every day. You can handle matters in-house, but taking into consideration what I mentioned earlier, handling certain matters in-house can cost the practice far more than getting a consultant or attorney involved from the beginning. Look out for those red flags. Know when you can handle something in-house. Know when something is routine. And when it's not, or you're not certain, consult with a consultant. Consult with an attorney, and then decide based on their reading of it whether you need to retain them going forward. Take your time in determining if something is routine or not. And again, the best thing I could tell you is you are all smart. You all have good common sense. Trust your instincts. Most people have told me in the past, oh, you know what, this request, it sounded bad. This request sounded different, sounded odd. If you if you don't trust what you're receiving, by all means, kick it up to the physicians to see if they want to get an attorney involved or a consultant involved. The last thing you want to do is not use your common sense. Use your common sense, trust your instincts. They're right more often than not. So thank you so much. If you have any questions, I'll answer them now. If not, this is my contact information if you have any questions in the future.
Okay, folks, we're going to open it up to questions now, and we'll just read them off one at a time. So please, if you have questions, get them into us. So Guillermo, the first question is, can you record them if they come into your office?
It depends on what state you're from. New Jersey is a one-party consent state, so as long as you're consenting to it, then yes, you can record. Whether it's in your best interest, I don't know, because if you say something that's incriminating, then that's on tape. I would say what I usually tell my clients is once they've left, write down everything, date it, sign it if you want to do that. That's a very good contemporaneous note, and that you can absolutely use to refresh your recollection at a later time.
Okay, folks, any other questions today? I did get a few questions regarding the presentation, and yes, as I stated in the beginning, I will be sending the presentation out electronically, A recorded version will also be behind the members-only firewall on njmgma.com. Okay, doesn't look like there's any other questions. So Guillermo, thank you very much, and thank you everyone for attending. I'll get the presentations out to you later today. Have a great day.
Thank you so much. Have a great